Good afternoon. Your deposition. You probably never had a deposition taken before, and what I want to do in the next few minutes is to simply share with you some of the common ground rules and the common do's and don'ts that you should be aware of in your deposition. Your deposition will be taken in our offices or that of the opposing attorney. The typical persons present in a deposition are the opposing attorney who would be asking questions, you and myself, or a member of my staff, an attorney here, to represent your questions, to make sure that the questions asked of you are appropriate and are related to your injury and background and things of that nature. The way deposition typically breaks down is, first of all, you'll be sworn in as a witness. You'll be asked to swear under penalty of perjury that the testimony you give is true, complete, and accurate, and to the best of your ability. At a later point in time, you'll be given an opportunity to review that testimony. It'll be put into a booklet form, and when you review it, you can then check to make sure it's accurate as well. And if anything is inaccurate, you can put a line through it with your initials and put in what is accurate, if that is necessary. We like to avoid that happening because if you change your testimony, it can be used later by the opposing side during the time of trial or other proceeding to show that you said one thing when your deposition is taken and then something else later. So we want to make sure your deposition testimony is accurate when you say it. Number one, you don't volunteer. You only answer the question which is asked of you. Number two, listen to the question completely before you start your answer. You don't want to talk on top of the attorney who's asking you the question because it's very difficult for a court reporter to get down two people talking at the same time. And we want to make sure that we have a complete question before you provide an answer. It also provides me the opportunity to interpose an objection if one is appropriate. Don't guess in answering questions. If you don't know an answer, it is far better to say you don't know than to provide a guess. The difference between a guess and an estimate is a simple one. If somebody asks you what the length is of, say, the dining room table at my home, unless you've been to my home, you wouldn't know and you'd be guessing. Likewise in a deposition, if you're asked the speed of a vehicle or the content of a statement made by somebody, don't guess at that unless you know it. If you know it or you remember the substance of it, it's okay to provide that. But don't guess. Guesses only end up hurting you because it's sheer speculation on your part and doesn't serve you well. It is far better, too, for the other attorney to hear you say, I don't know, or I don't remember, in giving a guess. If you need to take a break at any time, you're welcome to do that. Depositions can go an hour or two or three, sometimes longer. And every hour or so, more or less, depending on what I see of you and see of your appearance, if I see that it looks like you need a break, we'll take a break. If you want to take a break and I'm not noticing it, please do tell us that you need to take a break and we'll be happy to stop for you. During that time, we can talk. Our conversations, both in preparation for the deposition and at the deposition, are within the attorney-client privilege. The other side cannot ask you, what did you talk to your attorney about? It's none of their business. That is protected from any exposure. Share with me all the details of your case in preparation. If there's something I should know that we haven't already talked about, or even if we have talked about it, bring it up during deposition preparation if you think it has any relevance to your case at all, and you think that you may be asked a question about it. That may include things about your background that we may or may not have discussed. I want to know any details. If there's something in your background that could prove harmful, be sure to tell me about that, because I can take steps to avoid problems we might encounter if there's some piece of information I don't know. Just answer the question. That's a key to it, and it shows the other attorney, too, that you know what you're doing and you've been properly instructed and you're following those instructions. So be aware of those simple guidelines. A deposition typically breaks down into three basic areas for this type of case. Number one is background information. Where do you live? Who do you live with? How long have you lived there? Who are your family members that you live with there? What kind of work do you do? How long have you been employed? Where else have you worked for the last 5 years? Where else have you lived for the last 5 years? Just background information. The second area is the events surrounding the accident or basis for your claim, whether it's an automobile accident or an injury in a nursing home or medical malpractice. The who, what's, and wherefores of how that happened are important. The third area is of the injury that you suffered. Typically, my clients have suffered pretty severe personal injuries of various sorts, and there will be a history to that. That is to say, whether it started on the day of the accident or there was some history before that, but there'll be medical treatment involved, and you want to have a good idea, at least of the chronology of what has happened to you physically with respect to any medical treatment that you've had. So that'll be the third area. We'll cover all that when we meet in person to talk about your case, but this preliminary information, we thought it advisable to share with you on tape because it is basic and it gives you the general outline of what will happen. Don't worry also. The scale of things, your deposition is not that big a deal. It's important to pay attention during a deposition and in our preparation and now as you think of it. But don't worry. I've handled thousands of depositions over the course of 35 years. I know well on your case, as we will talk about, what and how to express it and when to express it in a deposition if it's something that you are asked. If you aren't asked, and I think important in a deposition, we'll say it then. But don't forget, a deposition is the defense's opportunity to learn about your case. Should they fail to ask you questions about it, it doesn't mean that it will not be brought out. Still be brought out in trial. This is like their cross-examination of you. If they don't ask the questions, don't worry about it. If it's something that I feel should be in the deposition, even though the other attorney has not asked you about it, I will do so at an appropriate opportunity. Lastly, sometimes in depositions, I will interpose objections. The question will be asked, I'll say objection. The question is ambiguous. I don't know what you mean by whatever it is. And many times when I make an objection like that, I'm also talking to you. I'm knocking on the door and saying, listen to this, be careful here. He's trying to be tricky, or she, trying to be tricky. So listen carefully to that question. Make sure you got it before you answer it. And if you don't understand it, say you don't understand it, and then they have to rephrase it. If you do understand it, then go ahead and provide a response. It's another thing to be aware of during a deposition. Answer only questions you understand. If an attorney uses a lot of legalese, a lot of gobbledygook in a question, simply don't answer. Say, I don't understand that. Can you say it in a different way? Can you rephrase it? And they're obliged to do so. So if you follow these instructions, I think you'll do well in your deposition. We've had great success for many years, and it's because clients listen and follow our instruction and our advice to them, and if you do so, I'm very confident we'll have good success in your deposition, which is only a part of the case. Thank you for your attention to this, and I look forward to speaking with you in person.